Certainly. So,
Excuse me 1 minute. I'd like to recognize Mr. Pete Obermueller. He is the Executive Director for the Wyoming County Commissioners Association. Thanks for being here.
Happy to be here. Sorry to drop in totally unannounced.
That's okay.
Boy, that's scary.
I wanted to see where the magic happened.
I just said if we were going to talk about CUPs, you might want to come in and listen. So I thought good timing.
Exactly.
fantastic. Well, gentlemen, as you're aware, in our 13 zoning districts in Natrona County, we have what are called permitted uses you can use your property for without any question or additional scrutiny. And there are some conditional uses. Those are uses that, if are permitted in a large number, could be detrimental to that zoning district. And quite often when we get into these conditional use permit conversations, there's very unique circumstances that surround each one of them. And so to address those circumstances, we attach conditions to the conditional use permit. And those conditions are spelled out during the public hearings and or in the resolution at the end. So then, as time goes on, we have to manage these conditional use permits that we have granted. Historically, looking back on a 5-year time frame, we issue about 10 of those a year. So those get added to the slate, and we routinely go back through and audit our files and check for compliance on these conditional use permits. We have come across a few here in recent times that are not in compliance with their conditional use items. We've reached out to these folks via email, via written letters, phone calls, working with these folks to bring them into compliance. The main issue today is how do we want to approach these when they're not in compliant? Staff would recommend that we start looking toward a revocation of that conditional use permit. We've got legal here that can give us some guidance on the steps that we would go through on that aspect, but
Can you give me an example of when that would happen?
Yeah, so there's quite often there's a time frame associated with a conditional use permit. So you will have these conditions in place, whether that may be screening, maybe that's road improvements, maybe that's coming and getting a building permit for things you're building. And when folks don't follow through with those things, it affects our ability to not be a burden on the neighborhood. It's one of the 4 criteria when we go through a conditional use permit is it won't change the character of the neighborhood. So quite often these conditions are put in place to help protect the neighborhood, that this won't be a change in character.
So the basically in that case they just didn't follow through with what they said that they were going to do when they applied for the CUP. Would you ever revoke a CUP when they for violations outside of that agreement?
There are, in fact, it's in our zoning resolution that you can't have any other zoning violations on your property. If you have another zoning violation, that potentially could jeopardize your conditional use permit. To be perfectly clear, during my time here, we have not revoked a conditional use permit.
Okay.
That answer your question?
Yeah, thank you.
Anything else?
The only other side of it is we do have cases where we get through a public hearing and we're headed due south, so to speak. Everybody's on the same page. We approve it, and then we actually get out on the grade and we're building that cell tower or that collector car or whatever those cases may be. And there are modifications that happen. For instance, a cell tower, the road access, for good reason, may need to be moved to a different location. It's primarily the same access, but it's in a slightly different location. For those instances, I would propose that staff would have the administrative authority to at least give them a head nod on it and then come visit with the chairman about that to see if it needs to be brought to a broader audience or whether it can be approved internally. Of course, these are approved public hearings. We go through a public process, and we want to make sure that we're in compliance with everything that has happened in the past and track these in a better way. So that would be the other item is the modifications we're keeping the intent and purpose exactly the same, but perhaps the way we get there is a little bit different.
Mr. Chairman, I think that a lot of times that in those public hearings, people that are opposed to it are opposed to the whole thing, not necessarily where the road goes in. So if it's a small item, I think that's great. You could have latitude to figure it out. But if it's, usually, but you've got a sense of what the people talked about in those public hearings. So if it's something that was contentious, then you could bring it through the
Bring it back to the process.
And amend the CUP.
Mm-hmm.
Otherwise, just make the minor adjustment and instead of putting the access here, we'll put it over here. Same property, same landowner, just a different access point, and road goes across the same property.
Exactly.
Everybody good with handling that way on those CUPs, that type of issue?
If it's a small item, I think so.
We have to define small item, right?
Well, yeah, I think that's a judgment call.
Well, it is. I mean, you can't legislate discretion. So I'm just saying, okay, go therefore and don't screw up. It's basically what you're telling them, right?
Yeah. Haven't you had orders like that before?
I'm sorry?
You've had orders like that before.
I've had orders from assistant chiefs that, we've got an SOP in place where we're no longer doing 90-degree turns. So to make a left, I got to do 245s? What the hell?
Yeah, right.
You know what? So it's not always clear, I'm just saying. Right.
I realize there'll be some gray areas, and if there's any doubt at all, I'll come visit with the chairman at that point and make sure that everybody is agreeing with me that it's a minor.
Well, and if it was a point of contention at the hearing, then I think that in all likelihood should be brought back to the
Probably
board.
planning first and do run through the whole deal.
Right, got to pretty much run through if it was a point of contention or if it's a major change, if they're going to access it off of a different road or something.
Yeah, the height of the tower changes or the location.
Yeah.
I think bottom line for me, I mean, we hired you as a manager. We all have a lot of confidence in the work that you do, right? But I think there's always going to be changes, and there's always probably going to be something new come up, right? And so I think we're always going to have to be involved without being a micromanager from our end, right?
Okay. I think everybody's good with, as long as you're aware of it and they let you know. And the other issue is on actual enforcement of the CUPs where they are in, I guess you'd say, violation of the agreement.
The conditions they agreed to, yes.
Yeah, the conditions that they agreed to. And we've exhausted, gone beyond the allotted time, and we have attempted to communicate with them and not getting anything out of them so that we can move forward. You've actually even granted some extensions, as I understand.
We have.
Where they, because of weather, et cetera, well, we're going to have this happen as soon as the mud dries up and so on and so forth. And even then, you can't get them to sign an agreement to
establish a deadline or to come to completion so that we can get this in compliance. One of the deals in a conditional use permit is after it's all in place, the development department will issue a letter of compliance to that applicant. So until they have that, they're not in compliance, and the development department wants these things complete, neat and tidy, and done as said. So when we reach a crossroads, that's exactly why we're here. When the applicant is no longer working with us, I guess at the end of the day, we've got to look at the process to revoke that conditional use permit.
And if we revoke a conditional use permit, what would be the next thing that happens?
They, after it's been revoked, I believe they could reapply.
Suppose they could, yeah.
And they would go back through the...
It seemed to be, if they didn't comply with requirements of the first one, I don't know that applying for another one would be way to follow up.
Yeah,
I guess you
that's
could.
just a never-ending cycle if you issue a new one, unless the circumstances have substantially changed.
I guess the action point would be you would revoke the conditional use permit, and then you would cite them for a zoning violation.
Okay,
And
so a citation would follow.
And they would go to a citation, and then there would be a remedy through the citation process for removing that citation.
Would you ever come to a public hearing about revoking it?
You'd have to, and it's a, would have to be a contested case hearing with a basically a full-blown trial. But the Board of County Commissioners would sit as the judges, the fact finders in the case.
So it would be a public hearing when you revoke it? Then?
Right.
Yeah.
You don't have to have a public hearing to grant. You have to have a public hearing, sorry, but you don't have a contested case pursuant to the Wyoming Administrative Procedures Act to grant one. But if you want to, that becomes a vested property right once it's granted. So to revoke that, you have to have a contested case hearing, which is,
Okay.
not only does it take lots of time, it's very expensive.
Both sides. They'd be a whole lot better off just to finish it.
I'm just a little concerned that we're handing over the job that we're supposed to be doing and completely to you, right? I mean, if you have, as these things come up, I would hope that, he'd be coming in and visiting with us and giving us heads up and letting us know, always keeping us informed, right?
Well, if
calls or
he
emails.
revokes one, then we're going to be judge and jury.
But before it gets to that, though, right? I mean, there's got to be...
And he has been, and you've seen a string of those emails here lately on some of those issues, but perhaps not all of them. Commissioner Lawson?
Yeah. Question I have is, there's a date set on those CUPs, right?
Yes.
So there's an expiration, is this correct?
These conditions have to be met by date certain. Yes.
Otherwise, the CUP expires? That's my question. And it's more of a legal question between revoking and expiring.
It depends on what it says. But generally speaking, once it's granted, it doesn't expire ever. It's granted with conditions, and the only way you can revoke it is to have a hearing to do so, contested case hearing to do so.
So you've issued CUPs for a short period of time to get something accomplished, is this correct?
Just take that question a little different.
Excuse me, Commissioner has, but we've issued CUPs for a short period of time to get something resolved, is this correct?
We've issued CUP for, once you grant CUP, it's forever, but you have, one of the conditions is you have to have this done by date certain, and that's typically 12 to 18 months. You'll have screening in place, you'll have necessary signage in place, you'll have the building permits in place.
So there is a deadline set for that condition. And if that deadline is not met for that condition, the only result that the only thing you can do is revoke the CUP?
That's my opinion, because it's somewhere you're going to have a staff determination that has not been met, that requirement's been met. So there you're entitled to your contested case hearing as to whether or not the requirements of the condition have been met.
And there's been times too, excuse me, John, can I add?
Yes.
There's been times too, though, that the applicant has gotten extension.
Sure. Yeah, but all I'm thinking about is, and they just keep coming for extensions after extensions after extensions until you're driven into this process that I just heard Mr. Knight tell us, and that is revoking, which is a fairly laborious process from what I heard you describe.
Revoking a permit, from what I hear you're saying, revoking a permit that really wasn't issued because they didn't meet the conditions, is that what you're saying?
Well, we issued a permit and then we put conditions in it.
Right.
And they didn't meet the conditions, so I would think that the permit
hasn't been issued.
you know.
Would be null and void.
Would be
Right.
null and void.
Right.
I'm just
Because they didn't meet.
Because they didn't
Right,
determine
exactly. I see
without,
what you're
without, us,
saying.
without us having to go into this process that I heard Mr. Knight describe, because that's going to be a contentious, laborious, expensive process is what I'm picking up on.
Based on, you know, I can't cite to you a case that I've read in the last couple hours on that regarding that type issue, but generally speaking, if you're even if you go out, somebody's got to go out and say, well, you didn't meet that condition, and they're of course going to say, yes, I did. I met that condition, and so before it expires, we're going to have a full hearing to determine whether or not that condition was met or not.
So they're entitled to due process.
It's a due process issue completely. And when you are revoking a private property right like that, then you trigger the contested case scenario. So, of course, pretty liberal on what gets contested because it's a due process issue. So. I didn't think about the, writing him a citation for failing to meet one of the conditions. I haven't really thought about that. I don't know if that would.
I know it was more along the lines of once we had revoked a conditional use permit, then we would write the citation, because without the conditional use permit, the use would be in violation of our zoning resolution.
But if they don't meet the condition,
Okay.
let me think on it.
Well, then then it's got to go before the judge, and then the judge tells them you've got to get this done in 20 days or whatever.
Well,
okay.
the penalty only says that you pay a fine, and that's, it would be nice if it said, if you want them to go to an injunction to force them to do something, you got to go civil. Usually the judge says, I won't fine you if you'll do this. That's how they get worked out otherwise. But
Then if they don't do it, then it's a major deal, because the judge told them they had to do it. Not us.
Sometimes it has been, sometimes the judges seem to be more lenient than we have.
Go figure out.
Mr. Chairman, so what happens if they pay their fine? And then we're back to square one, and we write them another citation,
There you go.
and we just keep doing that?
That's exactly right. That's the danger of citing. And then, of course, their argument's going to be, well, the statute does say each day is a new violation.
Wow.
So, but it doesn't ever get accomplished what you want to do. And then no judge is realistically going to find someone, $75,000 for a zoning violation.
No.
So,
Mr. Chairman.
Commissioner Lawson?
So what I understand is you're going to look into this, Gordon. What I understand is as long as there's a CUP in place, you can't write a citation?
no, as long you. That's. I think we probably can. It's just without me, just like we do on our zoning resolution. If you go out there and you have, a use that's you don't subdivide the property, you don't fill subdivision, you have a use that's not allowed in your area. That's a zoning violation. We write citations for that. So I think if you fail to follow the conditions of your conditional use permit, you'd also be committing a zoning violation.
Okay, so what we need to do here today is we need to give Jason a direction, because he's got a couple of issues, yeah. He's got a couple of conditional use permits where he's gone months beyond and still cannot get the people to either respond or take the appropriate actions. So is that your advice, is we just go ahead and write him the citation at this point?
Well, it may be tomorrow. Let me think about it for right now. But the other option is to revoke it. I know what that entails, but it's certainly not a minor process by any stretch.
Okay. I would say that's the direction we want to go. Is we have to, we've exhausted our remedies, and we have to move forward with our own regulations. You know, we either put teeth in them or we don't have it. It's kind of where we're at.
I hate to say this, and I know you guys cringe when I say it, but sometimes when we go to court, we find out what we can and can't do because the statutes aren't clear on every position, and there's not much case law in Wyoming that tells us what you can't do. So if we write them a ticket, the judge may tell us we can't do that. Well, at least we'll know.
True.
There's worse things from the legal perspective than lots of lawsuits because that at least defines and interprets the statutes for you, so you know what the court says, and that's one of the obstacles we face in Wyoming is that there's very limited case law, and even more limited on zoning regulations. So that's worth a shot.
Is that a satisfactory answer for you?
Certainly,
Is to
Mr. Chairman.
provide, is to proceed, move ahead with the citations and attempt to remedy in that fashion.
Certainly, we will do it that way, pending any change of heart he may have. And
Commissioner Slaughter?
Mr. Chairman, I guess in the future what I would suggest is when you have exhausted all reasonable administrative recourse, that's when you go forward and
that's where
go
we're at.
forth, and I think that's where we're at, and I think that's it.
Yeah.
The advice is what I would say in the future, let's do that.
Yeah. I believe we've talked about at least two separate instances where that's the case, where we are months, beyond getting any even response from the applicant.
Have lots of documentation.
yes, sir.
Okay.
Any other questions?
No, I appreciate the time and the direction.
And thank you, Jason. Okay.